Legal research and writing form the bedrock of a successful legal career. These skills are not mere procedural necessities. They are the very tools with which lawyers advocate for their clients, analyze complex legal issues, and navigate the intricacies of the justice system. Mastering these skills is not an option, but an imperative for any lawyer aspiring to excel in their field. The ability to effectively research the law and articulate arguments in writing is essential for building compelling cases, providing sound legal advice, and ultimately achieving favorable outcomes for clients. Legal research is the compass guiding lawyers through the vast and often complex maze of statutes, regulations, and judicial precedents. It is the process of uncovering the relevant legal authorities that govern a particular situation and using them to build a strong legal argument. This meticulous process demands a keen eye for detail, a deep understanding of legal principles, and the ability to synthesize large amounts of information into a coherent and persuasive narrative. Equally important is the art of legal writing. A lawyer's writing is their voice in the courtroom, their advocate in the judge's chambers, and their counselor to clients seeking guidance. Clear, concise, and persuasive writing can mean the difference between a winning argument and a missed opportunity. The ability to communicate legal concepts effectively, both to those well versed in the law and to lay people, is paramount. It is through carefully crafted legal documents that lawyers present their cases, advocate for their clients' rights, and ultimately influence the course of justice. Effective legal research is a meticulous process that demands both breadth and depth of inquiry. It begins with identifying the key legal issues at play in a case. What are the specific questions that need to be answered? What are the relevant areas of law? Once these questions are clear, the research process can begin in earnest. A lawyer must be adept at navigating both primary and secondary legal sources. Primary sources form the bedrock of legal research and include statutes, case law, and regulations. These are the authoritative statements of the law, and understanding how to locate, interpret, and apply them is crucial. Secondary sources, such as legal encyclopedias, treatises, and law review articles, provide valuable analysis, commentary, and context for understanding primary sources. They offer different perspectives on legal issues and can help to deepen a lawyer's understanding of the law. Legal writing is a distinct form of writing that demands clarity, precision, and persuasive force. A well-crafted legal document should not only inform but also persuade its reader. It should present a logical and compelling argument supported by relevant legal authority and ultimately lead the reader to the desired conclusion. Understanding the audience and purpose of a legal document is paramount. Who is the intended reader? A judge, a client, opposing counsel? The tone and style of writing should be tailored accordingly. The IRAC structure, issue, rule, application, conclusion provides a useful framework for organizing legal analysis. This method ensures that legal arguments are presented in a logical and structured manner, making it easier for the reader to follow the line of reasoning. Clarity of language is crucial in legal writing. Avoiding legal jargon and using plain English whenever possible is essential for ensuring that the message is understood by all parties involved. Proper grammar, punctuation, and citation are not merely formalities. They are essential for ensuring that the writing is professional, credible, and persuasive. Navigating the landscape of legal documents, a guide to different forms. The legal profession relies on a diverse array of documents, each with its own unique purpose, structure, and conventions. Legal memoranda, for instance, are objective analysis of legal issues, often used to advise clients or colleagues. Briefs, on the other hand, are persuasive documents filed with the court, advocating for a specific legal outcome. Contracts, the backbone of countless business transactions, demand meticulous attention to detail and a thorough understanding of contract law. Client letters serve as vital communication tools, explaining complex legal concepts in a clear and concise manner. Legal opinions, often sought for their expert analysis, provide authoritative interpretations of the law. Mastering these different forms of legal writing is essential for any lawyer seeking to effectively represent their clients and navigate the complexities of the legal system. Each document type demands a specific skill set and an understanding of the nuances of legal drafting. The power of professionalism, writing that commands respect. Professionalism in legal writing extends beyond mere grammatical accuracy. It encompasses respect for the court, colleagues, and the legal profession as a whole. This respect is reflected in the tone, language, and overall presentation of legal documents. Maintaining a courteous and professional demeanor, even when addressing opposing counsel or disagreeing with a legal argument, is crucial. Personal attacks, inflammatory language, and emotional outbursts have no place in legal writing. Conciseness is also a hallmark of professional legal writing. Every word should serve a purpose, and unnecessary verbiage should be eliminated. Judges and clients alike appreciate writing that is direct, to the point, and respectful of their time.